Good afternoon, everybody. We are about to commence the 5th meeting of the Joint Select Committee on Local Authorities, Service Commissions, and Statutory Authorities, including the THA. I would like to indicate that this meeting is being broadcast live on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView, for those interested in following this live hearing. Also like to inform that the audience, the public, can send comments via email at parliament101@ttparliament.org or our Facebook page at facebook.com/ttparliament or on Twitter at ttparliament. My name is Ian Roach, and I'm the chairman of this committee. I'm assisted by other members who are asked to introduce themselves. Before, I'd like to welcome you to this hearing and thank you for your presence. We hope to have a fruitful public hearing this afternoon and deal with it within the time allotted, which is about, I think, we have about 2 hours here this afternoon. Hopefully it will be very informative. I will start by asking the members of the Joint Select Committee to introduce themselves, starting with our Vice Chair.
Ramona Ramdial, Vice Chairman. Ramona Ramdial, Vice Chairman.
Hi, good afternoon. Welcome. Stuart Young.
Good afternoon. Jennifer Bitties Primos.
Good day all. Welcome. Darrell Smith.
Good day. Welcome. Nigel De Freitas.
Good afternoon, Faris Arawi, member.
Mr. Chairman, I would like you to, sorry? CEO. I would like you to introduce yourself and your other members with you. But put on your mic, please, so you can be recorded.
Good afternoon. I am Hazar Hussain, Chief Executive Officer of the Land Settlement Agency. To my extreme right is Ms. Sasha Dabro, the manager of our 10-year regularization unit. On my immediate right, Ms. Oma Munu, senior accountant. On my immediate left, Mr. Everson Bida, who is our land use planner. And on the extreme left, Mr. Sachinan Basau, senior design engineer.
Now, I would like to remind you why you are here. Is this inquiry is to assess the current state of squatting on state land in Trinidad, to evaluate the effectiveness of the agency in executing its mandate, particularly in relation to A, regularizing of eligible squatters, and B, the containment of squatting. Also to determine whether the resources, systems, and procedure of the land state agency, LSA, are sufficient to allow it to operate efficiently. I'd like to thank you. We received your submissions and acknowledge it. It was dated the 14th of March, 2016. And we have had an opportunity to go over it. And I guess you will get some questions coming from it itself. I will now invite you, Mr. Hossain, as CEO, to make a brief opening statement.
Okay, we're indeed pleased, my team and myself is indeed pleased to be here and to present before the committee. The LSA has been in operation since 1999. The Act was passed in 1998, Act 25 of 1998. At that time, members of the public who were squatting were invited to apply for regularization. And you had until the 27th of October in the year 2000 to do so. The LSA received approximately 23,000 applications as at that time for regularization. Since then, the number of squatting households has increased to our best estimate to approximately 55,000 households in Trinidad. And if we use the average of 4 persons to 1 household, we are talking approximately 220,000 persons squatting in Trinidad. It is indeed a major issue that the state needs to put resources to deal with, both financial and human resources. Because this is an issue that affects all of us, and the numbers keep growing, and we are of the opinion that if we don't put a stop to it, we will continue down this road for a very long time. The present state of regularization is affected by the increase in squatting, because as we regularize, new persons are coming into sites, and the number of sites are growing. We started with 251 sites that was listed in the Act. Our best estimate puts the number of sites at this time at 350 sites in Trinidad. Chairman.
Thank you very much. Thank you very much. I will now invite members of this committee to ask questions as well through the chair. Yeah.
Thank you very much, Mr. Chair. Through you, one of my first questions, I see we have the land use planner here, Mr. Beder. I'd like to know, what is your interaction with the Ministry of Planning? Because as people may or may not know, under the Planning Act, of course, we're supposed to have a master plan that sets out how we're supposed to deal with certain areas of Trinidad and Tobago. And then we have squatting communities that have developed over time. Certainly in the capacity of the LSA, what is the interaction with the Ministry of Planning?
Okay, good afternoon, everyone. We follow the rules set by the Town and Country Planning Division. Whenever we start a development, we would apply for an outline planning permission. This would give us whether we can go with residential based on present planning policy. When we get the go-ahead, we will do our plans and we will submit for final planning permission. So we stick within all the rules set by the Town and Country Planning Division. We used to do small plans based on our sites. And in the past, we used to send some of these plans to the Town and Country Planning Division. For example, we did a study of squatting in Port of Spain. And we supplied a copy to the Town and Country Planning Division as well as other state agencies.
Thanks. So what you've confirmed is there is a very interactive and current relationship going on between yourselves and the Ministry of Planning, and you're always keeping them not only aware of what is going on by the latter part of what you just said, but also, in fact, before you commence any development, you go through the normal process like everyone else,
right,
which is seeking the planning permission.
Even before we submit the final, we have built relationships with members of Town and Country. We actually could go in now and sit with one of the planners and look at, because we use standards that are sometimes different from the normal standards, and try to get buy-in from these technical persons before we actually make the official submission.
Okay,
Thank you very much.
Thank you. Good afternoon again, everyone, and to the listening public. We're dealing with a very important issue, and I'd like to just take a little step back into some of the data that has been provided. Thank you, first of all, for a very well-written report presented to this committee in answer to our several inquiries.
You're welcome.
You have stated at page 1 of your inquiry that the survey, the social survey done, the last extensive one in the period 2009 to 2012, evidenced somewhat a number close to 25,000 squatter families, over 300 squatter sites. It's now estimated at page 1 again that there are approximately 55,000 households, so that figure has gone up from 25,000 to double that figure, 55,000. And we're now looking at approximately 220,000 persons. If you go with just a multiplier of 4 persons per household, it may in fact be more. What I'm concerned to know, in following on upon Mr. Young's question, in relation to the requirement to have Town and Country scheduled approval, a master approval for squatting communities, the LSA Act only prescribes a certain number in the Act. My first question is, was there an approval process that has confirmed now the planning authority for those existent sites described in the legislation? So is there the requisite town and country identification for those particular sites as listed in the legislation? Secondly, insofar as specifically the proposal on the last Parliament's agenda table was for a broadening of the number of sites with an invitation that, in fact, a schedule was produced in an amended bill which described a significant increase in that number. Was there similarly town and country planning approval within the contemplation of the Act for that broadened list of sites? And the question following from that is, what mechanisms were put in place to track and monitor the number of applicants invited to go onto those broadened sites to become regularized under the proposed legislation which didn't launch off the last Parliament's table? I'll start with those three questions.
Okay. Okay, with respect to the Town and Country and Planning Authority, as I pointed out earlier on, there are 251 sites listed in the Act. The LSA has been doing regularization on an incremental basis, meaning that it's impossible for us to approach all 251 sites. So what we do, we plan for a number of sites. What we're doing right now, for example, we are planning approximately 30 sites out of 251. Over the years of operation of the LSA has regularized and put in infrastructure in approximately 30 communities, 30 sites. So we have not approached Town and Country for approval for all of the sites. Secondly, with respect to what was attempted to be brought before the Parliament. Now, a number of sites was listed, and parliamentarians, as far as we understand, submitted names of sites. Now, as far as tracking the number of squatters or squatting families, what the LSA has done over the years is that we have gone out to the sites, as we've shown in the social survey, and we have picked up all squatting structures and have attempted to pick up social data on all squatters. The information we have, as you pointed out here, 25,000 squatting families were social surveyed back in the years 2009 to 12. That was an 80% survey. It was not a 100% survey. Many parts of Trinidad, especially in the northern part of Trinidad, we were unable and advised not to social survey certain areas because of certain issues. The survey was 80%. We did about 300 out of 350 sites. Out of that 25,000 that was surveyed, 7,000 of those persons matched our database. That's the reason you're seeing the discrepancy now between the 25,000 and what we estimate at 55,000. Only 7,000. It means that there were 16,000 families that did not match the database that we had at the LSA, and we assume that they are in various parts of the country, not necessarily what we describe as a site. Hence the numbers from 25,000 to 55,000. So if we add the 25,000 to the 16,000 that we did not find, that gives us approximately 41,000. During the years 2009 to 2015, the number of squatting households grew by approximately 6,000. And that is factual data that we have actually picked up on the ground, new structures. It's bringing the number closer now to 50,000 or thereabout. And there are certain jurisdiction that we don't have control over. For example, there are squatters on colony lands, described as spontaneous settlers, approximately 3,000 families. Those numbers add up to 55,000.
Sorry, Mr. Chairman, just to get the answer, thank you very much on the numerical point. Is there planning permission within the context of the Act for the 251 sites listed right now? And was there planning permission for the additional 100+ sites to be added on?
There's not planning permission for all 251 sites. The planning permission exists for the sites that we have actually put in infrastructure works. That's approximately 30 sites. We are currently doing 7 new sites. We have planning permission for those sites.
And the question that was last left, thank you very much, perhaps in the run-up it got lost. What tracking mechanism and phenomenon did you see from the launch or the expectation in people's minds that, look, we're going to be more of us regularized when the last bill came out? What kind of numbers did you get? And the tail end question is, what sort of invitation was made to parliamentarians, and who were the parliamentarians that actually submitted these proposed sites for regularization?
Okay, and the question of tracking mechanism, the LSA has, what we have is our containment division that goes out into sites, limited staff. We go out into sites on a daily basis and attempt to pick up all new squatting. We have a total of 13 officers at this time trying to patrol the whole of Trinidad. The numbers has increased tremendously. From our estimate, over the last 8 or 9 months, the numbers has gone up. We probably have about 700 or 800 new squatting families, and that's only what we have picked up. There are many more.
Okay.
Say that, please.
Thank you. So, Ms. Ramdi, I would like to ask you a question.
Thank you. Mr. Hussain, in your introduction, you mentioned about the explosion of squatter settlements and putting a halt to this. The Land for the Landless program was one mechanism by which it was supposed to assist with respect to halting the wanton squatting across Trinidad and Tobago. Can you give me an update with respect to this program? What is happening with that Land for the Landless program?
The Land for the Landless program was launched in 2012. We have gone through 3 years of that program, and we are developing sites as we speak. We are developing sites as we speak. In fact, we are developing close to 10 sites at this time. Some of the sites have received full approval as we speak.
Just a follow-up question, Chair. So those applicants, relating to those sites, at what stages the process for the applicants, their application, at what stage are they at this point in time?
We have approximately...
Have you been able to distribute any of the lots?
We have approximately 56,000 applicants since the start of the program. No lots has been distributed to date. As I said before, what we have been doing is developing lots and trying to get the necessary approvals before lots are distributed.
So the program is ongoing, right?
We are continuing with our program.
Okay, great. Thanks.
Hi, good evening. In your report, you suggested that the top 5 geographical regions and municipalities/corporations and constituencies were Grandy, Point Forte, Diego Martin, which I was formerly the chairman of, Port of Spain South, and W. Mirror. The reason why I bring this up is we used to have a meeting, and the corporation have a coordinated meeting, and every now and then, that's once a month, the last Tuesday, and LSA will send a representative every now and then. That's consistent as we would have liked. But one of the things that we constantly asked was for figures in terms of how many squatters were in the geographical areas so we could assist. And we used to try to work with them, with our municipality police, to see how we could try and stop it from happening, because once anchor is laid, it's difficult to remove and so on and so forth. But in those 5 areas, I always ask, because we were trying to push a proper database and database analysis, because what we found was most of the issues we got in the local government avenue was in those areas that were squatting in terms of lack of infrastructure. But they will build up over the years, and of course, they will get regularized or not, but they become part of the voting public and so on, and we'll have to go in there and do major work because of that. But do you all have any figures with regards to those 5 areas, Grandy, Point Forte, Diego Martin, Port of Spain, and W. Mirror?
Yes, I can give you estimates, and we could provide further details in writing, but I can give you some estimates of what we estimate the numbers are. The area of Sandy Grande, and I'll probably make the statement, is the fastest growing squatting area in the country, because there's lots of forestry lands in that area, in Valencia, Sandy Grande area, and persons are going to those areas. They are actually destroying our forest reserves as we speak. We estimate that there are somewhere between 7,000 to 10,000 squatting families in that entire area. Point Fortin, another very large area, we have over 3,000 squatting families in that area. It could be more because Point Fortin, the number of squatters are increasing. Diego Martin, in the River Estate area especially, we have approximately 3,000 squatting families. Port of Spain South, I'll have to provide those details for you, Port of Spain South, but it's a huge number. Now, we talk about Port of Spain South, and probably we looked at Katanga and those areas, but if we look at the hillsides and Port of Spain, some estimates, and we are not sure about this because we've been unable to do the surveys, some estimate put the number of squatters in the hillsides of Port of Spain and environs as close to 20,000. However, not all of those are on state lands, because you have state lands intermingled with private lands, and no comprehensive survey, perimeter survey, has been done to establish the squatters on state lands as opposed to the squatters on private lands, all abandoned estates. I'll continue. Dabadi, Omira is another large area. I'll give you one example. The Dabadi, Omira would be the area of Karapo, where that's an area that we've developed over 7 to 1,000 squatting households in that one vicinity alone. Now, you mentioned the regional corporations. On a weekly basis, we've taken a decision, on a weekly basis, we submit, the LSA submits to every regional corporation the number of new structures, new illegal structures that we pick up. It's submitted to both the regional corporations and to the Commissioner of State Lands. And I'm glad to say here that there was some cooperation in the past, and that's one of the areas that we are looking forward to get cooperation, where the corporations within their power can deal with illegal structures. But we have had very limited success in dealing with illegal structures. The LSA itself, Chairman,
Yes.
does not have the power to contain squatting. We have never been given that power in our act.
I realize this is one of the amendments you all are seeking.
Exactly.
Right? Yeah, I mean, like a bulldog without any teeth. Huh?
Exactly.
Yeah. Member Primus.
Thank you, Chairman. My first question would have been the question, given the response that you just gave, Mr. Hussain, to outline some of the squatter containment initiatives. Notwithstanding the fact that the LSA does not now possess such authority, what would be some of the containment measures would you like to see in place? Because it seems it's very clear that squatting has spiraled completely out of control in this country.
Chairman, with your permission, can I ask Ms. Dabra to answer that question?
Sure. Yes, please.
Good afternoon, members. In terms of mechanisms, the approach, I'm an attorney at law. I've been with the Land Settlement Agency for 10 years. I've been in practice for approaching 17 years. Some of the mechanisms, apart from legislative review, which I can discuss a little more further detail, we need to establish stronger alliances and networking relationships with other state entities and administrators of state land. Starting with the top, the Commissioner of State Lands is the custodian of state land as ordained in the State Lands Act.
Yeah.
And all the ultimate responsibility for squatting actually resides with the Commissioner of State Lands.
Yep.
As a matter of fact, under the Land Settlement Agency's governing legislation, we are referred to Section 20 of the State Land Act to address any non-compliance with relocation or any matters that may involve containment. We are directed to refer such matters to the Commissioner of State Lands. What can the Commissioner do? The Commissioner can institute proceedings before a magistrate's court. That has its own small success and more challenges than that we are aware of for several reasons. So the Commissioner is currently also in need of some legislative attention to give him some sharper teeth and more summary powers when it comes to dealing with squatting on state land. Therefore, in our time, or in my time, I should say, in looking at legislative review, we have looked at it collectively. I've looked at it not just on behalf of the Land Settlement Agency being given stronger teeth, but more so the Land Settlement Agency and the Commissioner of State Lands be given wider powers, more summary powers, more immediate powers, for reasons because of the challenges that they face. For instance, to commence summons, to serve a summons on someone, a squatter who's not giving their name, it stops right there, it stagnates. The DPP's office has been swamped with matters that have gone nowhere because they don't have a name to go forward. State land inspectors sometimes face challenges, they face threats, they face other forms of incentives that to prevent them from dealing with taking the next step to commence summary court proceedings. Therefore, the legislative review that has been proposed over the years has looked at all the challenges, and we have proposed other ways of dealing with legislative review for the Land Settlement Agency and the Commissioner of State Lands. Now, we're also saying, in my respectful view, that creating legislation or enhancing legislation is not a new thing. We already have legislation that the CEO intimated earlier, which resides with the municipal corporations and to some extent town and country planning as well. The municipal corporations do have the authority to address persons who construct any building on any form of land, any tenure, without the relevant permissions and approvals. Unfortunately, it's a very difficult decision to arrive at when you have, it's a political decision. It's a council having to pass a resolution that may very well wipe out an electoral district in the event of a decision to demolish or to remove a structure, but that is in fact the powers that currently reside with municipal corporations. A building inspector in a corporation can identify an illegal structure without an approval, state or private, and the council can take a decision accordingly. So creating legislation for the LSA and the commissioner is not going to resolve the problem if we haven't resolved how to enforce existing legislation and to enforce the sanctions that currently exist. We also have to be more aware and responsive in terms of reporting matters, having strong administrative procedures in place to address collecting data, updating data collected, the service of notices. There are several procedural things that could be enhanced as well. Resources, the Commissioner of State Lands Office, as far as I'm aware, has been severely depleted over the years. I don't want to speak on behalf of that office, but we have had a very close interaction because of the fact that we work on state lands. As a matter of fact, when the Commissioner of State Lands Office was first removed from the Ministry of Agriculture and put in its own ministry in 2013, I think it hit home that many of the officers who were actively working on state lands were actually employees of the Ministry of Agriculture and not of the Commissioner of State Lands. So it's a holistic approach. I think we can't also ignore public education strategies. I think our publics need to be bombarded with information of what is not acceptable, what is acceptable, what must be done. There must be some form of training, because at the end of the day, we could make the best laws, but we have officers who have to implement them. We have to be sure that an officer understands what is an abandoned structure, what is a structure in the course of development, to know what action to take. Your view of abandoned may not be somebody else's. So we have to be very careful how we write these laws for the average layman to implement, to understand, and to enforce. I would respectfully suggest that I have personally, in my time, had an opportunity to look at all these areas. And there's another big monster called adverse possession, which has also come into play in the proposals. And I would like to see that go forward actively.
Have you, this is a very comprehensive answer. I mean, it's very enlightening. A lot of what you say is
Forgive me for rambling. It's very passionate,
I can
Chairman.
see that, and we appreciate that somebody like you is part of the agency.
Thank you.
But have you given some of those views put forward?
Yes.
That you have?
Yes.
Okay. I have a further question from Mr.
Mr. Chairman, I would just like to thank Ms. Dabra for such a very frank and comprehensive response, and one recognizes that you bring a certain level of care in what you do.
Thank you.
So thank you very much, Mr. Hussain. On page 27 of your written submissions, you indicated in response to the question, is the current staffing arrangements at the LSA adequate to treat with its various activities? you would have indicated that the current organizational structure comprises 193 positions, which really, those positions are adequate to meet and treat with the core responsibilities of the LSA. May I inquire how many of these positions from the 193 are vacant, and what percentage, if any at all, are contract as against permanent positions? And thirdly, how many of the vacant positions are managerial positions?
Okay, to answer your question,
Wait, totally. I want to link it to page 29. I don't want to engage in asking you or question by question, but I hope you would have listed the three.
I think you better give short for him, man, because, yeah, break it up for him.
No, it's how many of the 193 are vacant, how many are contract, how many are permanent, how many are managerial. I also want to link it to page 29 of your written submissions and to inquire, and I'm referring, this fourth question is in reference to Romans 6. What are the policies and procedures in place to ensure accountability, transparency in procurement of goods and services for the LSA? You responded that the LSA, among other things, you responded by indicating the LSA has also engaged the services of a procurement specialist to assist with procurement-related activities. Who is the procurement specialist?
okay. So I'll start with the first question regarding the number of staff. There are 193 positions, but not all of that is full. In fact, we have, at this time, approximately 90 contract positions which are full at the agency.
90 are filled.
90. We have, at this time, approximately 30 temporary staff at the agency. We also have with us OJTs, close to 30 OJTs at the agency at this time. The number of managerial positions that are vacant at this time, and if we look at senior manager positions, we have one senior manager position which is vacant at this time, manager of corporate services.
So only one managerial
Senior manager position, yes.
No, senior.
Yes.
Are there other lower-level managerial positions?
Yes, we have a number of other middle manager positions which are vacant, especially within the technical side. Even a senior attorney position is vacant at this time. We have been unable to fill a number of these positions over the years. We have advertised, and we've been unable to attract persons to these positions.
How many of the middle managers' positions are vacant?
At this time, we would have approximately 10 middle managers' positions vacant.
Mr. Hossain,
Chairman.
what would you say have contributed to the significant increase in squatting in Trinidad?
Well, I think
There seemed to be an explosion.
Yeah, I think Ms. Dabro answered a lot of that in that we really don't have laws, and it's really the implementation of the laws that we do have. It's not being implemented. As she pointed out, the Commissioner of State Lands has the power to contain and to follow the process. The regional corporations has powers built in. The town and country has powers, but there has been a...
There's an unwillingness, is what you're saying, basically?
Well, you can put it that way.
Or they're not motivated to be politically correct. You're not sufficiently motivated.
Probably that.
I see.
Mr. Chair, sorry, if I may, it's really to follow up on a point Ms. Dabro made towards the end of her very useful submission, the public education point. I think that I would like to respectfully suggest that that is a very, very big element of it, because I think the majority of Trinidad and Tobago at all levels are not aware of the full extent of the law. Right, so and you all would face this, I'm certain, on a daily basis of people thinking they can come in, get certificates of comfort, that you could provide them with some level of regularization, not realizing the period for that left about 16, 17 years ago. So I think I'd like to suggest we have a bigger public education process. I'm certain you all have done it before, but this, as you have pointed out, is a live issue. Because every day you all are picking up more and more squatters. And I'm certain you're having people come in on a daily basis seeking regularization and not being aware of the law. I would like to suggest that you focus some effort on the public education process. That's the first point. The second point that interests me is that you said that on a daily basis we have people out in the field trying to ascertain what is going on with squatting, etc. And you've established quite clearly here that your agency is not the one that has the powers to stop and to make people, not to enforce the law, let me put it that way. And one of my colleagues said a short while ago, there's been an explosion, I think it might have been the chairman. Based on your statistics, there was an explosion. You used the period of the last 9 months. And he was asking, why do you think there was such an explosion? In the period of last year, in 2015, and in particular, say the first half of 2015, was there any abnormal rise in the level of persons being picked up for squatting?
If I can just give you some of the statistics that we have. 2015, the LSA picked up 1,011 new squatting structures. And I'll just go back a little bit.
Could you give
to
us
emphasize
the areas,
point.
if you have the areas where they were?
I don't have that details
Okay,
here. 2014, 1,167 new structures. 2013, 944 new structures. And most of these are now occupied.
Of course.
2012, 822 new structures. 2011, 447 new structures. 2010, 996 new structures.
So based on those statistics you've just given us, it shows that in 2014, 2015, there was an abnormal rise in the number of squatting establishments set up, and as you quite rightly point out, occupation of these establishments. Okay.
And also, if I might point out, we are doing an exercise right now where we are attempting to pick up more data. And there are also a tremendous amount of structures, unoccupied structures as well. It shows that people are speculating. They're speculating, they are putting down frames in the hope that no action will be taken. And at some point in time, they're going to occupy, or maybe dispose of those structures, sell those structures to other persons. And we saw in the press just recently where persons are actually selling structures. So they're building and selling.
Sorry. Yeah? Go ahead, please.
Mr. Hussain, just drawing from what Member Batiste Primus was asking you about employment and vacancies, it has come to my attention that over the past couple of months, at least 25 to 30 employees of the LSA has been sent home. Is this true? And if so, are they contract employees? From what departments can you identify and clarify?
No employees from the LSA has been sent home as far as our records show.
Thank you.
Yes, Mr. Hossain, what impact has the HVC housing scheme has had or having on the squatting? Is there any tempering of it? I mean, is there sort of a synergy working with the HGC and your agency?
Well, definitely we have synergies working where we work with the HTC, but to say that that has had any impact with the growth in numbers, I would say no, because if the numbers has increased from 23,000 applicants back in the year 2000, October of 2000, to what it is now, the numbers have grown steadily, and there has not been much of an impact.
Now, in terms of the squatting, just probably Ms. Diablo may be able to answer this. There's a qualification to be a squatter, right? To be regularized. It's a time limit.
Yes.
And there's a certain profile, social and economic. Am I right?
Well, yes, Chairman. Answering partially because in terms of our ability to regularize certain persons who are squatting in accordance with the provisions of the Act, there are certain characteristics that we need to meet in order for those persons to be eligible.
Okay.
So it's not just squatting, roving, squatting. Persons must have applied a proper application. There are several persons who applied and their applications are faulty. They have to have applied within the requisite time frame. Mr. Hussain indicated early in his opening submission, the 27th of October 2000. Actually, what the Act prescribes, it's a 1-year period and a late application period of an additional year. So if the Act was enacted in 1998,
Right.
1 year and an additional year takes us to the 27th of October 2000. The person must have attached certain requisite documentary proof showing that they were in fact on those lands by the 1st of January 1998. So even though the application period was the 27th of October 2000, the presence and occupation of a dwelling house on state land must have been by the 1st of January 1998.
Right.
And of course, the most challenging issue is it must be state land.
Now, tell me, what happens where persons who are applying do not qualify? What happens to them? Do they remain squatters? How are they regularized? Are they evicted? What happens in those circumstances?
Persons who have submitted applications and they are not successful for one reason or the other, each of those persons, a letter is written under the hand of, coming from my unit. We inform the person of the reasons for their lack of being recommended for a certificate of comfort, which is the first stage of regularization. Some persons, unfortunately, are on state lands, but it's on sensitive state lands that are not eligible to support regularization. Persons sometimes have applied, and it turns out that they're on private lands. They're not eligible. Persons have applied without a signature. We tell them what the reason is, and we direct them, if necessary, to the Commissioner of State Lands for assistance if, in fact, they're on lands that are not under the jurisdiction of the Land Settlement Agency. In terms of removal, no, there's no action taken. However, if the person is in occupation of land that subsequently turns out to be a site that has received approvals for development, that person, are you hearing me clearly? Okay. That person would be able to be regularized, but not through the traditional course by the LSA. That person may receive regularization directly from the Commissioner of State Lands.
You're saying there's not a clear consequence for if you don't qualify. I mean, you're a squatter per se. I mean, your chances either way still kind of
That issue is encompassed in some of the holistic recommendations in reviewing the legislation. It doesn't speak to how to address matters such as those. As a matter of fact, it's a sensitive issue that needs to be addressed, and there needs to be buy-in and sponsorship from the policymakers. Very, very hesitantly, I would call it the need to look at extended regularization to address persons in that category, or alternative forms of removing them from those lands and understanding what the ramifications would be. Because at the end of the day, those persons are in occupation sometimes of lands that have already received physical infrastructure upgrades, development, and perhaps the state may be better served by having those persons pay for their occupation of state land, perhaps at a different rate.
That's a very good suggestion. Yeah, sorry. Member Batiste Primus?
Thank you very much, Chairman. Mr. Hussain, I was assessing the information flow from you a short while ago, and I don't think you answered my question.
Sure.
How many of the positions are vacant? You indicated to me that there are 90 contract positions filled, 30 temporary with 20 OJTs. But actually, how many of the 193 positions are vacant?
Remember, if we look at the organization structure, 193, and if we have approximately 90 full, it means that we have 103 vacant positions at this time. Contract positions.
How many of the 193 positions are contract positions?
All 193 are contract
All
positions.
193 are contract.
Yeah. All employees at the LSA on the organization structure, it's contracted.
So you have approximately 120 vacant positions still, you said?
103.
103. All right. Having said that, Mr. Chairman, through you, Mr. Hussain, on I'm still on page 27 of your report. It deals with the shortfalls in your developmental program, and it states by how much. My question is, how will these shortfalls that you have identified impact on the delivery of the projects you have in mind? That's one. And two, given the downturn in the economic situation in the country, have you all sat down and reviewed the plans that you would have developed?
Let me answer the first question. The shortfall has had an impact on our delivery. And I just want to go back a little bit, in that the LSA has only been able to develop approximately 30 sites over the 16 years of operation. And that is because we have been financially starved for funds to continue our development work. It cost the LSA at this time approximately $130,000 to $160,000 to develop each slot for a squatter. And when we are given such limited funds, it's impossible for us to continue our development program. We would have started a number of planning, pre-construction activities at a number of sites. In fact, as I said before, approximately 30 sites. And we have only been able, for this particular year, we are working on 8 projects, sorry. Now, when you look at the number of squatting sites, and if we are doing 8 now, when we have done 8 in 5 areas, in 5 sites, and we have done 30 in the past, if one tries to project when we are going to finish regularizing what we have now, bearing in mind the number of new squatters that are coming on, I'm not sure where we are going to finish because we are starved for resources.
But why does it cost $130,000 to develop per lot or per squatter? What are the embedded costs inside that figure?
And to answer that question, the main thing goes back to standards of development. We are required, if we are going to give this squatter, according to the Act, tenure, security of tenure by a deed of lease at the end of the day. In order to do that, you have to bring each squatting lot up to the full regulatory standards as required by the Town and Country, the EMA, Drainage Department, WASA, etc. So each lot must come up to the full standard. So what you have in any squatting site that we have finished developing, Milton Village, Cashew Gardens, you have a lot that is fully developed with full standards at the end of the day, and to do so requires that funding.
Isn't also the IDB has stated a standard as well to be in order to release to get access to the funding?
Exactly.
Which was incorporated into that.
One of the measurables under the particular loan is that we are required to give leases. And to give a marketable lease, it means that we must meet all the development standards.
Mr. Smith?
Yeah, thank you, Chairman. What is the relationship and alignment you all have with the Ministry of Public Utility and Ministry of Agriculture with regards to, firstly, the illegal hooking up of water and electricity and so on, very, very soon with regards to the workers, and even with agriculture, because I know it would be difficult if somebody is squatting and they're doing very well with farming, but they do it very quickly. What is the alignment you all have with regards to that?
And remember, that's a huge issue, and one that we've raised. Persons who are within a certain distance of electricity poles, for instance, according to the law, can have a electricity connection. Similarly with WASA connections. And that, in our mind, has encouraged squatting as well. Because if persons are getting connections, getting water and electricity, 2 of the basic things that you need for survival, and you can get this once you're within a certain distance from these utilities, then they will continue to squat.
Mr. De Freitas, sorry.
Coming out of the response that you gave in regarding to having different rates, wanted to ask the question, in your submission in response to the question, how many squatters were regularized over the past 10 years, you indicated that there were 25 squatters that had paid in full and that the LSA had granted 11 deeds of lease. My question is, what is the average cost of a squatter? What is the average cost a squatter would be required to pay for a lot of land situated in, let's say, Sandy Grande or Port of Spain South, which was part of the list of the top 5 areas that you had given earlier? And also, is there a standard selling rate or pricing formula, for example, cost per square foot?
Okay. Now, there is a policy in place for payment for squatters. The price is based on a per square foot cost. There's a $5 per square foot infrastructure cost, and a premium of 20%, which is based on the value of the land. So, for instance, land, if a squatter is squatting in the Port of Spain area and that lot is fully developed, the price is based on the value of the land in that area. So the price that a squatter will pay for his lot in Port of Spain or in the borough of Shogunas, for instance, would be more than a squatter will be paying for in Moruga or La Savane, because it's based on value that is put by the valuation department of the Ministry of Finance. Now, one of the questions asked before was in relation to what are we doing? We're short of funding. And one of the things that the LSA that we have been pushing for is to have squatters pay for their lands, have them pay for their lands, and we can reinvest that same funds that we get when we receive those funds to reinvest and develop the other squatting sites. Now, Mr. Abro mentioned about the differential pricing. Now, there's a price for squatters who are eligible under the Act. And we also said that for those who are not eligible, or who came after the year 1998, we have suggested that they pay a different price, a higher price for the lands. But there are issues involved in that as well, because which must be addressed, because we have squatters who have come onto some of the developed sites this year, last year. Are we going to allow them to get a subsidized price also? And that has to be addressed.
Yeah, isn't one of the criteria that you must not own other lands or any other property?
Definitely. That's one of the stipulations in the Act.
But from my information, I mean, I've heard, there are people who own property that are actually squatting as well. So, I mean, what assistance do you require, or what agency will necessarily be required to be informed and seek these people out and do something about it?
Yeah, we have close relationships with the Registrar General Department, at Commissioner of State Lands Office, with other state enterprises. And before a lease is granted, an actual search is done to ascertain whether that squatter, who is now moving from certificate of comfort to a deed of lease, to ascertain whether he owns other property. And if it is that he owns other property and it's picked up, he would not be entitled to a deed of lease.
Just engage me here a sec. I saw in the criterion assessing and given, there's a sort of a point system, right? In determining whether a person will be qualified to get.
That's under the Land for the Landless program. That's not with squatters.
Okay, fine. Okay.
Yeah.
Because what I wanted in that, just based on what you were saying, one person may have cohabitants, and one person the land may be in his or her name, and the other one may not. So how we deal with that?
We search both applicant and co-applicant in the name of both persons. So we conduct in-depth searches at the Registrar General Department to ascertain whether they own other property.
Question for you.
Thank you, Chair. Mr. Hussain, with respect to the regularized settlements, as I understand it, there's a letter of comfort that is distributed, and then after that, a deed of lease. How has that been, with respect to your regularized settlement, how has that process been going to date? And how many, if you can tell me at this point in time, has been distributed to these persons within these regularized settlements?
Okay, so the first part of the tenure process is a certificate of comfort.
Yes.
Okay, and from the certificate of comfort, you can only move to a marketable deed of lease when we get the full approval for the sites. We have regularized a number of sites. That means putting infrastructure in these sites, and we are working with the regulatory agencies to bring these sites up to the full standard so that we can give marketable leases. As Ms. Dabra pointed out, we have given out just 11 leases so far, but we have close to 3,000 lots that we have regularized and put in infrastructure, and we are working with WASA, Drainage Department at this very time, trying to get the final approval for these sites so we can now offer the occupants who are eligible under the Act leases.
And what about the letters of comfort? That first process, that first stage, have those been distributed to those
The agency has processed some 7,700 approximately certificates of comfort to date, and we continue to process the balance of certificates of comfort.
Thank you.
You have Mr. Smith.
Thank you, Chairman. I saw in the strat plan, one of the things that you brought up was for you all to become a self-sufficient agency. What is your strategy? How you all going around getting to that point?
And the strategy, as I pointed out before, is once members of the public contribute towards this asset that they are getting, land, a valuable asset, and they contribute by making their payment towards that, and with an adequate pricing policy, the state can recover at least the infrastructure costs that we are putting into each development. And if we can recover the infrastructure costs, it means that we can reinvest that into other settlements and become more, we can manage ourselves at some point in time.
Thank you, Mr. Chairman. Mr. Hussein, I want to play agent provocateur here. 30 sites in the past 16 years. One would say that the Land Settlement Agency has failed in this regard. Would you agree with that school of thought?
No, that's not, we would not say that. Again, I'll go back to the issue of being starved for resources, where we have not received adequate resources to do our operations. And I'll just give you some statistics just to prove the point here. Now, provisions to the Land Settlement Agency over the last 5 years. 2015-2016, $72 million. And that's the highest provision that the agency has received.
How much?
$72 million. 2014-2015, $40 million under this quarter right component. 2013-2014, $10 million. And I gave you before the example how much it cost the agency to develop one lot of land to full standards. 2012-2013, $20 million. 2011-2012, $15 million. 2010-2011, $8.5 million. Now, this is the sums that we receive over the last 5 years or so has hardly been enough to develop one squatting site, and hence the reason we have not been able to develop more than 30 over the years.
So these squatters, is it that they pay the market value for the land or subsidize some for the land? Because it's costing the Land Settlement Agency, based on what you said, $130,000 to develop for one squatter. So what are they paying? Market rate or subsidized rate for the land?
It's a subsidized rate, as I pointed out before. It's based on a pricing policy that's been approved of $5 a square foot plus a premium of 20% based on the value of the land. So if I take an average lot, the squatter will pay somewhere between $50,000 to $80,000 for that lot of land. So it's still a subsidized price. Now, we also drew the example of the persons who don't qualify under the Act, but are benefiting from the state resources. Because when we put in infrastructure, we put in infrastructure for entire site, 30% may qualify under the Act, and 70% does not qualify under the Act. And they continue to live anyhow without paying. And we have suggested at the Land Settlement Agency, we have suggested that they should make a contribution. And those persons who do not qualify under the Act should pay a higher price, closer to the market value, or closer to the infrastructure cost that we have put in, so we can recover. And in that way as well, if we have that sort of scenario, we can have cross-subsidization where you have persons that contribute in a higher amount who do not qualify under our particular act, and that revenue can go towards developing further sites.
Mr. De Freitas.
Yeah, just in keeping with what you're saying, and I just wanted to ask a few questions, and if you can indulge me for a bit. You were talking about, first question I wanted to ask really is what exactly is the definition of a squatter? Because we were talking about having individuals on the land that may not qualify for whatever reason, and other individuals who are squatting but they have land elsewhere. And the reason I'm asking for the definition of a squatter, because inherent in the name, it tends to suggest individual in need of living space. And in keeping with what we're seeing in terms of data from the HTC, where the need for living space by individuals is more than the supply, and that seems to correlate with what we're seeing with the alarming increasing in the number of squatters. I'm asking that question: what is the exact definition of a squatter? Is somebody who puts up, let's say, an animal pen on state lands and grows food in terms of agriculture? Is that person qualified as a squatter? Because that person could be living somewhere else and then utilizing state lands where they're not paying. And secondary to that, you were indicating that you do the check to find out whether somebody else, so somebody who's squatting has land elsewhere at the point where you want to issue the certificate of comfort. What I'm asking is if that can be done at an earlier date. So, for example, when you collect that data to see there's been an increase in 100, 200, or 1,000 squatters on particular sites, if you get name and information from them and you do the check at that point to realize that they have land elsewhere, and then maybe that could be a way of containing the increase or enforcing, because you know that they're not going to make it through the entire process.
I'll let Ms. Dabro give you the legal definition of what we consider a squatter to be.
Thank you, CEO. Member, I would read from the Act, the interpretation section defines squatter as a person who is in actual occupation of state land without probable claim or pretense of title thereto. In a nutshell, it means, in accordance with the definition in this Act, perhaps there may be another definition elsewhere, but we are bound by the confines of the Act that governs the Land Settlement Agency. It refers to persons in occupation of state land without legal title or a probability of one. In terms of doing the checks prior, unfortunately, once more, it does make a lot of sense what you're recommending, and that is again where legislative review must catch those anomalies. The Act asks us to determine ownership of other lands or landlessness at the point at which a deed is being contemplated, not at the stage of the certificate of comfort. Why? Because the certificate of comfort doesn't vest any legal interest at that point. It simply confirms or grants protection to that squatter from ejectment. At that point, the Act did not contemplate, or the legislators at the time didn't contemplate determining landlessness as a criteria or a precondition. They simply determined whether your application was in time, the component elements of your application are properly done, that you're on state land, and that you can supply proof that you were there before the 1st of January 1998. At the stage at which you're being contemplated for a deed, you have to show that you are over 18, a citizen, landless, and that you are in occupation of state land that is within a designated area now, eligible for full regularization and security of tenure. I would have loved to, as a matter of fact, we don't even have to determine ownership of the structure. The squatter has to show he was in occupation of a dwelling house as of the 1st of January 1998. That has its own challenges, because you find persons have applied and a real owner comes forward when the lease process is now the person is being engaged in the lease process. It's a very difficult piece of legislation to maneuver, and we have consistently worked on all these little areas that need to be addressed.
Mr. Hossain, I know that the LSA is concerned with Trinidad state land in Trinidad, but have you, and Tobago House of Assembly is in charge of Tobago. But have you all communicated with Tobago? Is there a similar problem of squatting in Tobago as severe as it is in Trinidad?
You're right, we don't have jurisdiction over squatting in Tobago, but from our information is that there's not that severe problem at all in Tobago as we have in Trinidad.
Why do you think so?
Why do we think so? Mr. Dabro can probably answer that.
We had a conference in 2014, and we invited members of the THA to make presentations, and papers were presented on specifically squatting in Tobago. And the Tobago House of Assembly recognized that whereas there is a squatting problem, it isn't widely reported because the nature of the squatting is a little different from the squatting in Trinidad. Their challenge is what they familiarly call family land. Apparently, Tobago is made up of several large unmanned estates that have been caught up in family ownership, perhaps without administration, without probate, without proper passing and disposing of one's interest to another generation. And persons live without knowing clearly where defined boundaries are, who is the clear owner. So it's a different nature of squatting. And
There's more title disputes as opposed to a squatter.
correct, and it's within families. That is just the general trend we get coming from the THA. However, at that conference, I did have some discussions with one of the officials, and they did indicate that the problem is growing. I don't know where this figure 30,000 came from, but I'm remembering a figure of issues that surround that figure of squatting. It may not be state land, however, but there is a growing problem. It probably hasn't reached such alarming stages as in Trinidad.
Sorry,
Mr.
yeah.
Hussain, just going back to the Land for the Landless program, I know you were telling me that those sites still need approval. How soon before they get approval so that these lots can be distributed? Do you have a timeline? Do you have an estimation of how soon before you get approvals for these sites?
Well, we are working with the regional corporations along with the other statutory agencies to get the approval, final approval for all the sites and get all the approvals before we can issue a marketable lease. Time frame, it's a continuous process. We have gone through selection in terms of draws, etc. Persons have been shortlisted, and as we get the approvals, I guess the distributions will take place.
Okay.
Could you tell us, in terms of your contractors that you use, who are the top 10 contractors you use in effecting your mandate?
Well, Chairman, we have an open and transparent process where we have conducted pre-qualification exercises over the years to attract contractors, consultants to do work for the LSA. In fact, the present IDB loan, our contractors are pre-approved by the IDB because we have done pre-qualification exercises. I can certainly provide the name of the contractors who are presently working with the LSA that has been approved through that process.
Okay. You have a question here?
Thank you, Chairman. Mr. Hussain. Page 10 of your submission. You spoke about, under the Land for the Landless program, the LSA has developed approximately 1,385 lots, with 400 lots from Greenfield Development, 988 lots formerly developed by the EMBD, which have undergone upgrades to meet the requirements for the various statutory agencies. And I see that you have here with you Mr. Stachand Basau, Senior Design Engineer. I trust I have pronounced your name correctly? Not okay, but close enough. Were these, through you, Mr. Hussain, were these upgrades required due to inaccurate project design specifications or contractor error?
Good afternoon, members. Most of these upgrade works would have been to satisfy the regulatory agency's approval process. A lot of the standards would have changed over time when we inherited those lands from the EMBD. For instance, the drainage division. they had upgraded their standards. So a lot of these developments was done to more or less meet the requirements of drainage division and even WASA. So they would have been done to prevent flooding, downstream flooding. But we have completed a lot of the works in those sites, and now it's just now for the agencies to provide us with the relevant approval.
So is it that you are saying that it was not as a consequence of contractor error or inaccurate project design? I've not been able to discern either.
No, definitely not. Over the years, they would have updated, as I said, their standards for development, and we would now have to upgrade. The problem was that the approval process was not started post-construction at that time. So when we inherited the lands from the EMBD, we now had to initiate the process of the approval, and standards would have changed. So we had to now meet those standards. So once those deficiencies in the standards were identified, we went in and we did the repair work. So on certain sites, we had to do detention ponds. We had to upgrade WASA installation. We had WASA come back in and update some of these sites for us. But all of those works have been completed.
The intention of the EMBD was to do the same thing as the LSA.
Correct.
So I'm trying to grapple with the change in standards. In that space of time, standards would have changed that would have made the LSA have to engage in these upgrades, wouldn't it? Shouldn't the EMBD be following the same standards that the LSA is following?
The standards would be guided by the statutory agencies like WASA, Drainage Division. So their standards would have changed. Now the process for development would have started 4 years prior to actual construction. So you're looking at about probably 4 years of planning and design, and then probably 1 year of construction. So you're looking at about 5 years. So within that 5-year period, for us to get the final approvals, standards would have changed. Now, EMBD would not have applied post-construction for their approvals. When we inherited the lands, we now had to take up from where they left off and then invite the agencies now to do inspections on the site and identify what deficiencies there were so that we could now effect the repairs so that we could get a regulatory approval.
Mr. Bassau, the public service doesn't change as rapidly as we would like the public service to change. And we are talking about statutory agencies here. Are you saying that the standards would have changed under the statutory authorities, that the EMBD would not have had to follow those standards that the LSA is following?
It would be fine tweaking of the standards to prevent mostly mitigation measures for flooding, for like drainage division. And those were some of the things that had changed. EMBD would have followed together with the consultants, their engineering consultants, they would have followed the procedures for the development. But because some of those lands sat there for some time, standards would have changed. Because we are now moving to do more drainage development within Trinidad because there is a flooding problem. So over the years, there's more stringent regulations regarding flooding, especially for land developments. So those would have changed.
I thank you for the explanation, Mr. Bassau, but I'm not fully influenced. But by your explanation, it reinforces that the LSA is very concerned about following procedures. I don't know that I'm in a position to draw a similar conclusion with regards to the EMBD responsibilities that I know are not the LSA's responsibilities.
Thank you. Mr. Hussain, you cited challenges with respect to funding for your agency as one of the hiccups in getting your projects and your plans implemented. What has been your budgetary allocation for this fiscal year? And in your estimation, what would have been a satisfactory budgetary allocation for your agency in this fiscal year?
Okay, so I can get into the development program budget for this fiscal year. We, under our quarter regularization program and under the vote that is there for the IDB program, we have $72 million. What would have been an adequate budgetary allocation under that vote? Maybe $200 million, so we would have been able to do our projects. But I've given some numbers of budgetary allocations in previous years as well, which was woefully short in terms of meeting our mandate. This financial year, has been the best year in terms of budgetary allocation for us for that quarter reg program, $72 million. Under our Land for the Landless program, we got $5 million this year. Again, that is short. Adequately, we would have needed more than $100 million to complete what we are doing. And then there's another vote, squatter reg vote, which is meant for projects not under the IDB program. That vote was not funded in this particular year. And then there's the survey of squatter sites vote, and I'm dealing here with the development program. We got it's $1.5 million, which is enough to meet our present requirement. On our recurrent side, we did receive most of what we require, and it's adequate to fund our operations for the year. $41 million.
Mr. Hussain, I think your agency is in a very unenviable position in executing your mandate. And it seems to be at odds because, in particular, your mandate basically empowers you to protect eligible squatters from being ejected of state land, right? That is one. And to facilitate the acquisition of leasehold titles by both squatters and tenants in designated areas, and to provide the establishment of land settlement areas. Is that so, right?
Exactly.
Yeah. But that is at odds with containing the increase in settlement. I mean, some agency has to work hand in hand with you all to be able to bring this under control. This is something like they could dip in a bucket into the sea.
And Chairman, you
to empty the ocean.
Chairman, you're so right. And let me again, it's only examples can help us to understand what we're facing.
Yeah, it's significant.
I give the example of race course. When the LSA was finished with the race course development in 2009, we had approximately 400 vacant lots, which was earmarked for poor citizens to relocate other squatters into those areas and to make those lands available for eligible persons. Every single one of those lots were lost between the years 2010 and thereafter. We lost every single one. I give you the example of Bonnet.
Could you clarify for us, lost to?
Squatters has invaded and taken every single one of the lots. And these are lots that the state has put out, and I give the example, the amount of money we spend for each lot, $130,000, $160,000 at this time. So it means that the state has put out this money to develop these lots, and we are losing them to new squatters. I can give the example of Bonnet. When the LSA was finished with Bonnet, somewhere around the year 2009-2010 financial year, we developed approximately 450 lots. We had approximately 250 vacant lots on that site. Every single one of those has gone to squatters. And the LSA, as we have said before, doesn't have the power to protect them and to stop the new squatters. So we are indeed hampered. And you know, I need to make this point that as we develop sites, as we develop squatting sites, and we approximately, it varies from site to site, but approximately 30% of those persons are eligible under the Act to be regularized. You have the other 70% of the persons who are residing on the sites, who have come after the creation of the Act, who are also benefiting from all the state resources that we're putting in. So we need to make some adjustments.
Yes.
Chairman, in light of the response, the statement made by Mr. Hussain, would you agree that as an alternative to eviction, because you're saying depending on these lots that have been prepared, they have been invaded by squatters. In order to contain and prevent squatters from occupying state lands, and ensuring that they don't enjoy the facilities free, would you recommend or agree to the implementation of a squatters levy or a squatters tax for existing squatters to generate some much needed income for the LSA?
Certainly, I mean, with the, and if I get what you're saying, everyone should contribute through some sort of property tax towards whatever building you have
I'm saying they are not regularized, but they're enjoying the benefits. It's $160,000 to develop per squatter, so they are enjoying the benefit of the developed state of the lots. And in order to enjoy that, shouldn't they be contributing until they are regularized?
I agree with you, but we'll have to find a legal mechanism to do that.
I want to say, isn't that part of your recommendation? Is that part of your recommendations to have that incorporated?
I'm sure the passion of Ms. Dabro would work on that with a sense of expediency.
It is, it may not have been called a levy or tax, but certainly it would have required persons to start paying a SAP as of now, because the only challenge would be that we have to be certain that the expectation, which will be grounded in the minds of those persons, would be that they would be leading towards some legal tenure. The challenge is, and I think it was an argument that arose during the property tax debate about squatters paying taxes, is that once somebody starts paying taxes, there's an expectation that they are investing in this land, they're putting money towards their ownership in this land. So that needs to be managed well in terms of the type and the color of that levy, what exactly it's for. But I am certainly an advocate of paying for your occupation and presence on the land. I wanted to also add to what the CEO said earlier about the 7,000 odd certificates of comfort that have been prepared. That does not reflect the number of applications that have been processed. There's just as many processed applications which have not been successful, and there are at least 2,000 persons who have not been able to be located on lands. From time to time, we do publish names of persons. So it's not a reflection of 7,000 applicants that have been processed. It's 7,000 have been successful to date. We do have challenges in finding persons, determining their status, and other issues that touch and concern that. But Member Primus, Baptiste Primus, I do agree with your recommendation, and it is part of the proposals in addressing persons who are currently in occupation of those lands. Excuse me.
Yeah. Mr. Hossain, I think you and your team have been very informative. I mean, I assure the public that is listening is very much enlightened by what has been ventilated this afternoon. It certainly has me a bit anxious. I saw a number of other persons, including my members here too, would be also anxious given the current situation that we are faced with, that we are hearing. It's quite alarming, you know, because it raises, I guess, deeper issues of constitutionality, whether people are constitutionally entitled to have property. Once you squat, you're entitled to have land, you know, as opposed to persons who are paying for other uses of land and so forth. So we have to find some sort of remedy that equates with being humanistic, but at the same time being responsible, you know, in settling something like this, because it can't be just go without consequences that you could just go on land like that. I mean, it will never end. It can never end. I mean, no budget will be big enough for you, you see. So I want to thank you and your members for coming this afternoon, and I will invite you to make any closing remarks you would like to share with us and the public.
Chairman, well, I think you've said it. No budget will be big enough for us if we don't contain further squatting. And that is first and foremost the area that we must address. There must be relevant laws, and there must be the will to implement to prevent further squatting. There must be viable alternatives provided to squatting. such as what the HGC is implementing. There are issues regarding financial resources, human resources that the LSA must be provided if we are to do our job and to adequately regularize the squatters who are eligible under the law. The relevant agencies involved must come together if we are to address this problem. There are a number of agencies, Commission of State Lands, the LSA, other state enterprises must come together if we are to deal with this problem of squatting. We must think about appropriate standards for squatting settlements. If we are going to develop squatting sites and put in full infrastructure to get to the level we are required to put in at this time, it is very difficult to contain the costs of development. So that's something that we must look at, appropriate standards for squatting settlements. There are other issues such as dereservation of sites that we must deal with. The squatters has taken over a number of sites, forestry lands, that must be addressed. Those sites must be de-reserved if we are going to move the process forward for regularization. No site has been declared as a land settlement area after 16 years of the passage of the Act. Hence the reason that the LSA itself is unable to grant a lease to other programs such as the Land for the Landless program, and we are dependent and we implement that program under the powers of the Commissioner of State Lands. So although the LSA is the developer and we are administering the program, we do so on behalf of the Commissioner of State Lands. We are suggesting that the move must be that we have these sites declared as land settlement areas so the LSA itself can adequately deal with those. So those are some of the broad statements I'd like to leave with you, and where we require assistance from all.
Clarification. These amendments, as was suggested, have they been forwarded to the relevant ministry for attention?
As we speak now, the issue of the laws pertaining to containment are before the Legislative Review Council Committee, and that has been addressed. And we have put forward over the years a number of amendments to the Act, and we, in fact, at our parent ministry, a cabinet note has been prepared at this very time to address that issue.
Okay. Thank you very much, Mr. Hossain. Thank you very much, other members. I would like to thank the media for your participation this afternoon. And hopefully, as I said, I think from my part and certainly from my other members here, we have certainly been enlightened, and we hope that what has been discussed here, whatever we can do as the Joint Select Committee in moving forward and motivating a much more amenable, a much more certain solution to our immediate problem in squatting, which is a major concern for all of us. The budgetary allocation is one part, but I can, as I said before, you can get as much money if the squatting doesn't stem. You will never have enough. So with that, I'd like to declare this meeting as being adjourned, and thank you and good afternoon to everyone.
Thank you very much.